uh, there may also be bill passed, any provisions with so and so. I'm sorry, Malad. Even if it is ultimately turns out that there was no necessity for the governor to have reserved a bill for the consideration of the president, still he having done so and obtained the assent of the president, the act so passed cannot be held to be unconstitutional on the ground of want of proper assent. This aspect of the matter, as the law now stands, is not open to scrutiny by the courts. In the instant case, the finance bill, which ultimately became an act in question, was a consolidating act related to different subjects, and perhaps the governor felt that it was necessary to reserve it for the assent of the president. We have no hesitation in holding that assent of the president is not justiciable, and we cannot spell out any infirmity arising out of the decision to give such assent. My lord, now your lordships may, my lord, kindly take Kesare Hind, my lord. Lord, this is, my lord, five-judge bench judgment, my lord. Lord, can I begin at 2? It's almost so that this is a few more paragraphs are to be read in this, my lord.
Your Lordship, may I mention one matter for listing tomorrow? Fresh matter, Your Lordship. There is.
Before Justice Maheshwari, not before this.
Oh, bless you.
Lord, I would respectfully, my lord, request your lordships to take volume V17, 517, page 6664, 6664. This is Kesare Hind judgment, my lords. Sorry, not V, 5, Roman 5. My mistake.
Page
6664.
triple six.
6664. This is Kesare Hind, my lord, Constitution Bench judgment. I'll just read 3 paragraphs.
5-7.
No, 17 में कुछ आ जाएगा.
Then triple six. Kaisare Hind
Kesare Hind, yes.
versus NTC. Yes.
Kesare Hind versus National Textile Corporation. So, para 1, 2, and 3 gives what the issue was before the court. Short, your lordship gets one. Para 1. Short but important question involved in these matters is whether the assent given by the President under Article 254(2) of the Constitution of India with regard to the repugnancy of the state legislation and the earlier law made by Parliament or the existing law could only be qua the assent sought by the state with regard to repugnancy of the laws mentioned in the submission made to the President for consideration before the grant of assent, or would it prevail qua other laws for which no assent was sought? Your lordships would mark 254(2) is just, my lord, the cause for exercise of 200. 254(2) says that if there is repugnancy between central and state law, then President would go under 200 and seek assent. The contention is, once the President grants the assent to the state legislation, the state law would prevail on the said subject, and such assent would be deemed to be an assent qua all earlier enactments made by the Parliament on the subject. The contention is negatived for the reason recorded hereinafter. It is held that consideration by the President and his assent under Article 254(2) is limited to the proposal made by the state government. The state legislation would prevail only qua the laws for which repugnancy was pointed out and the assent of the President was sought for. Proposal by the state is a sine qua non for consideration and assent. Just to broadly point out, suppose the Honorable Governor feels that it is repugnant to 2 central acts and forwards, my lord, for the assent of his Honorable Governor. But it is found that it was repugnant to 5 central laws. What would be the effect of the assent? And one of the main questions which arose was, can the assent ever be justiciable? I'm sorry, my lord. Yes. My lord, kindly now come to para 23. Para 23, the 6673. The learned senior counsel, Mr. Nariman, next submitted that the assent given by the President is not justiciable and placed reliance upon the decision of this court in Bharat Srivastram Sangh versus State of Gujarat, wherein this court observed thus: it cannot be said that the assent which was given by the President was conditional. The records relating to the above proceedings were also made available to the court. On going through the material placed before us, we are satisfied that the President had given assent to the act, and it is not correct to say that it was a qualified assent. The act, which was duly published in the official gazette, contains the recitals that the said act had received the assent of the President on so and so. Moreover, questions relating to the fact whether assent is given by the Governor or the President cannot be agitated also in this manner. In haste versus so and so, this court has observed we have no hesitation in holding that the assent of the President is not justiciable, and we cannot spell out any infirmity arising out of his decision to give such assent. My lord, now your lordships may kindly see, haste is again quoted, which I have read. I'll skip, my lord, para 25. In our view, for finding out whether the assent was given qua the repugnancy between the state legislation and the earlier law made by Parliament, there is no question of deciding validity of such assent, nor the assent is subjected to any judicial review. That is to say, merely looking at the record for which assent was sought would not mean that the court is deciding whether assent is rightly, wrongly, or erroneously granted. The consideration by the court is limited to the extent that whether the state has sought assent qua particular earlier law or laws made by the Parliament prevailing in the state, or it has sought general consent. In such a case, the court is not required to decide the validity of the assent granted by the President. In the present case, the assent was given after considering the extent and nature of repugnancy between Bombay Rent Act and Transfer of Property Act as well. President so and so. Therefore, it would be totally unjustified to hold that once the assent is granted by the President, the state law would prevail. No, that is on the facts of the case. Now, my lord, I would respectfully substantiate this submission, my lord, on the ground of doctrine of separation of powers, and, my lord, on the ground that non-justiciability of constitutionally coordinate organs is a part of separation of powers, my lord. And that is how, my lord, your lordships have construed. My lord, if your lordships can now consider coming to another angle from which, my lord, this can be seen. My lord, suppose assent is granted as per the aid and advice of the Council of Ministers. There is no dispute between the governor, the view of the governor and the view of the council. My lord, Article 163(3) specifically prohibits the court from examining what advice was granted. Consequently, as a consequence, my lord, it would also prohibit the Honorable Court from inquiring why and for what reason the assent was granted. This is one facet. Second, my lord, suppose assent is granted, justiciability, my lord, according to two judgments, it's not justiciable. Suppose the Honorable Governor chooses the route provided under the proviso, that first I would send it back with a message, then even that would be subject matter of judicial review. After the proviso, my lord, operates and the bill is again presented to him with or without modifications, he may choose to refer it to the President. That again can be subject matter of judicial challenge. Therefore, my lord, my respectful submit, my lord, thereafter it would go to the President. The President also may again choose to send it back to the legislature under Article 201. That again can be a subject matter of challenge. Thereafter, my lord, the President may grant assent. That would also be a subject matter of challenge. My lord, the question is, in the scheme of things, my lord, when the Governor and the President are exercising legislative powers, being part of the Assembly and the Parliament respectively, my lord, is such multi-pronged attacks by way of a judicial review is contemplated? And my lord, in my respectful submission, the answer is no. If your lordships can only come to, my lord, page.
So, see, if the assent is granted
Yes, ma'am.
by the governor or the president, no question, because it becomes a law. If it chooses to go through the proviso, whatever, it is taken to the logical end. So either he grants assent or not.
Can I just interrupt here with your lordship's permission?
But if the governor withholds it for unlimited period,
No, Lord, again, I'm not repeating it. Withhold is permanent withhold. It's an act by.
permanent withhold, because
Yes.
from your chart, permanent withhold and temporary withhold.
Yes, yes, that can be, but that's a possibility.
Yes.
But, my lord, please see, my lord, the title of Article 200. It said assent of the governor. Assent is one. It has three facets: grant, withholding, reserving. So what, in my respectful submission, is not justiciable is exercise of powers under Article 200 and 201.
So according to you, 200 is totally beyond the scope of judicial review
It's,
and justiciability.
my lord, it is not justiciable. Not similar, again, contrary to the.
Justiciable in the sense, it's a decision and decision-making process. The decision is not justiciable, that why the president or the governor has assented to. That may not be, court may not examine it. The court can examine this aspect if there is a question of repugnancy or question of constitutionality of law will come. There the court will not examine the assent, the court will examine the very competence of the legislation.
And the act itself.
Itself.
Act itself.
Exactly. Here the question is of decision-making process, not the decision ultimately taken. So in the decision-making process, the court, as the rightly observed by the question bench, will call for the file, for what purpose the state had sought assent, to what extent, what were the laws. That process can be examined by the court. So it will fall within the ambit of judicial review.
My lord,
What is not justiciable is decision, assent, but process is.
Lord, my difficulty
Yes.
is my difficulty means the difficulty which I foresee is multi-level challenges. For example, if grant of assent per se can be challenged, the option of the governor to send it, return it to the house also is a decision under 200. First option. That also can be challenged, that he could not have because there is no repugnancy, or their governor can also send it without repugnancy.
That's also
It's
decision.
already-
Decision, it will not be challenged.
It cannot be challenged. That's my submission. Lord, suppose he chooses that I would refer it to the president for presidential assent. That is also a decision under 200. My lord, and all this, my lord, are isolated and independent powers, but can be exercised consequentially also. For example, Lord, a governor may say that right now I am not granting assent, I am returning the bill. Amendment. The amendment may not be based upon repugnancy argument. He may just, the proviso say even desirability. The governor says that it is desirable that instead of, say, age is the subject matter. I am just giving a hypothetical example. Age is the subject matter. Then instead of 21 years of age, you are fixing, make it 25. It goes back. That is a decision, again, my lord, subject to challenge if your lordship holds that it is justiciable. Thereafter, my lord, the parliament, the assembly would return it with or without, my lord, the acceptance of his recommendation. Then also his option is available. If it is repugnant or otherwise required to be referred to the President of India, he can again refer it to the President of India. At that stage also, my lord, if it is justiciable, it can be put to challenge. Same thing would happen when the bill is received by the President of India, referred by. The President may again send it back to the House that I am suggesting something else, or according to me, the governor has not found it, but I am finding it, there is something repugnant, and I am returning it back. My lord, there is no prohibition. The President can do that. That is a decision under Article 201. Lord, again, that would be justiciable. Therefore, my lord, my respectful submission is that this being plenary legislative powers exercised by coordinate constitutional functionaries are, my lord, outside the pale of justiciability. My lord, because if it is a grant of assent, my lord, the question of, my lord, challenge will not arise, because then the act will be under challenge. Act can be under challenge, and there is no difficulty about it. There cannot be any argument. Lord, kindly have a look at page 254. First 253. Lord, I have read it, but just for ready reference, Council of Ministers to aid and advise the governor. 253. Lord, it is always, my lord, safe to save the jurisdiction of the court, and I am conscious of that fact. But, Lord, as it would, my lord, I would try to make it clear subsequently, Lord, this theory, separation of powers amongst coordinate constitutional functionaries, is a theory accepted in our constitutional principles. Therefore, in case of 200 and 201, Lord, it is, according to me, my lord, non-justiciable. Lord, please see 163, Council of Ministers to aid and advise the governor. But please see 3, the question whether any, and if so what, advice was tendered by ministers to the governor shall not be inquired into in any court. Kindly pause here for a minute, my lord, and let me give, my lord, one hypothetical example. My lord, the outgoing government has hurriedly passed a bill. It is sent to the governor. The new government is formed. The new government is not the same government. Some other party forms the government or some other leader becomes the chief minister. He may even advise the governor to withhold the assent, that now I would like to have a fresh mandate from the fresh electorate, from fresh assembly. Lord, the constitutional prohibition is what advice he has given you cannot go into. So in my submission as a consequence, what is done by the governor after that advice is also, my lord, non-justiciable. Court cannot go into it. Now, please see, my lord, page 254, State of Punjab versus Sodhi Sukhdev Singh, where, my lord, 163(3) came to be considered by the constitution bench of this court, my lord. My lord, only highlighted part, my lord, may be read. It is hardly necessary to recall that advice given by the cabinet to Raj Pramukh or the governor is expressly saved by Article 163, sub-article 3 of the Constitution, and in the case of such advice, no further question need to be considered. The same observation falls to be made in regard to the advice tendered by Public Service Commission to the Council of Ministers. Lord, then next, my lord, 107, page 255. Under Article 163(3) of the Constitution, the question whether any and if so what advice was tendered by ministers to the governor shall not be inquired into in any court. In view of the constitutional protection and the reason underlying such protection, I hold that in present case, the district court was right in sustaining the claim of privilege. My lord, this article itself, my lord, gives an indication that there are some communications amongst inter se constitutional functionaries which are put by the constitution beyond the examination by the court. Constitution, my lord, Council of Ministers is also a constitutional body. Their communication with the governor, if it cannot be examined, my lord, then the governor's communication with the president also cannot be examined. And similarly, any exercise of power under Article 200 would be beyond judicial review, my lord, or rather would be just non-justiciable. I'll not use the word judicial review, non-justiciable. My lord, your lordships may, I'm just for reminding para 297, my lord, Kameshwar Singh and Valluri Chaudhary, my lord, Kameshwar Singh and Valluri Chaudhary, my lord, which I referred to, my lord, kindly come to page 255, para 297. Both have, my lord, held, both, my lord, 5 bench judgments, that exercise of power under Article 200 and as a necessary consequence 201 is legislative in nature. My lord, I have said Bihar versus Kameshwar Singh and a Valluri Chaudhary. It has been noted that the governor and the president are part of legislature and assent powers are a part of legislative process. It is in this light that the question of non-justiciability must be examined. It is submitted that once a bill is resolved and receives assent, judicial inquiry into the propriety or necessity of such a reservation is restricted.
Say Commissioner Rose, I'm saying to the governor, not legislative. Commissioner Rose says that.
government or be government, the question is, my lord, as I have put it, my lord, in page 258, my lord, there are two issues. I'm not reading it. A, the 258, my lord. I'm not reading, I'm just, my lord, paraphrasing my submission. My lord, the decisions are policentric in nature. The very nature of the decision is such that your lordships may perhaps not have any judicially manageable standard based upon which your lordships would examine. Existence or non-existence is one thing. Whether there is an assent or not is one thing. But if there is an assent would mean all options. Then, my lord, based upon what, I'm posing a question to myself, the court would examine whether this assent was rightly given or wrongly given. Second, my lord, there is a concept of constitutional committee. And the constitutional committee under our constitution is respect for one organ by the other organ. We do not have, my lord, hierarchical system that ultimately every organ's decision or conclusion would rest in one organ. There are checks and balances. For example, my lord, legislative act enactment is subject matter of your lordship's judicial review. It's not a hierarchical position, but your lordship's power of judicial review. Any decision taken by the executive, which is not a plenary constitutional power. The executive takes several decisions. My lord, the ministry, my lord, makes a policy. Ministry takes a particular decision. There are several executive functions, administrative functions. They are all subject to judicial review. But when it comes to constitutional plenary powers, more particularly of the nature which are legislative, my lord, justiciability should be denied, my lord. That is my respectful submission, my lord. My lord, on which, my lord, I am placing reliance upon one judgment, Indra Nehru Gandhi versus Rajnath. My lord, here your lordships have seen, my lord, a adjudication by the court by an enactment was sought to be, my lord, upturned. Please have a look at, my lord, page 258. My lord, I'm skipping through, my lord, most of the things. I'm paraphrasing it now. My lord, page 258. Para 313, my lords have.
Yes.
My lord, the Chief Justice has. Page 258, para 313.
313.
313, my lord. Indira Nehru Gandhi versus Rajnath. Para 577. There is ample evidence in the Constitution itself to indicate that it creates a system of checks and balances by reason of which powers are so distributed that none of three organs is set up, it sets up, can become so predominant as to disable the others from exercising and discharging powers and functions entrusted to them. Though the Constitution does not lay down the principle of separation of powers in all its rigidity, as is the case in United States Constitution, yet it envisages such a separation to a degree as was found in Ranasinghe case, so-and-so versus so-and-so. The judicial review provided expressly in our Constitution means Article 226 and 32 is one of the features upon which hinges the system of checks and balance. Neither of three constitutionally separate organs of the state can, according to the basic scheme of our Constitution today, leap outside the boundaries of its own constitutionally assigned sphere or orbit of authority into that of the other. This is the logical and natural meaning of the principle of supremacy of the Constitution. But no constitution can survive without a conscious adherence to its fine checks and balances, just as courts ought not to enter into problems entwined in the political thicket. Parliament must also respect the preserve of the courts. The principle of separation of power is a principle of restraint. My lord, it is not a prohibition. It is a principle of restraint. My lord, the very nature of the function, at the cost of repetition, my lord, I am respectfully urging, is such that it is entwined with political thicket. There may be 50 considerations weighing with the constitutional functionaries. for which your lordships may not have a judicially manageable standard to examine and decide whether it is valid or invalid. My lord, then next judgment, I'll read only the highlighted part, my lord. MP oil extraction versus state of MP. The supremacy of each of three organs of the state, legislature, executive, and judiciary in their respective fields of operation, needs to be emphasized. The power of judicial review of the executive and legislative action must be kept within the bounds of constitutional scheme so that there may not be any occasion to entertain misgivings about the role of judiciary in outstepping its limit by unwarranted judicial activism being very often talked of in these days. So this is 1997 judgment.
Now we are in 25.
Now we are in 2025, my lord, and now again, my lord, this discussion is going on. And my lord, mostly, my lord, your lordship's intervention has been, my lord, for the benefit, but sometimes, my lord, it is believed that it is in the domain of executive. For example, my lord, one of the high court, since I have appeared, my lord, without naming, virtually the COVID management was being monitored, my lord, administered by the high court. And all our officers who were supposed to be working on the ground were sitting in my chamber and we were preparing the status reports. What is the vaccine available? What are the number of companies which manufacture remdesivir, which each company has by way of their raw material? What is the production capacity? What is the production capacity of each company? In how many days, how many remdesivir drugs will be made available, etc., etc., etc. So, my lord, that is something, my lord, which is avoidable.
That is micromanagement of the government function.
Well, your lordships have always, my lord,
That will never interfere with it to. We can't ask you how a district is to be administered, how your collective could function. But suppose if particular function is entrusted to the governor, the honorable governor, and if for years together he withholds it, will that also be beyond the scope of judicial review of this court?
my lord, I would say.
When this court has set aside the constitutional amendment itself, which had taken away the powers of judicial review, that no amendment should be called in question by this court. It has been found to be hitting at the basic structure of the constitution. So, and with the judgment, with those judgments, can we say that everything, however the highest constitutional authority may be, if it does not act, still the court would be powerless?
No, my lord. My argument, please do not misunderstand. My argument is not that the court is powerless. I am on justiciability. My lord, there is difference. There can be a power.
No, assent is given, not given. Reasons, we may not go into that as to whether the president was justified in giving the assent, as to why he has given the assent, as to why the governor has given the assent. But suppose if an act passed by a competent legislature, if the honorable governor only sits over it, that could still be the courts.
Yes, I'll answer that, my lord, in two ways. First of all, your lordships would not decide whether there is any justiciable power in the lordship or not based upon an extreme situation, my lord, which may arise. That is my first answer. And second,
Like you said yesterday, the hard cases lay down a bad law.
bad law.
And my learned brother said that hard cases lay down a good law.
Hard cases always lay down a bad law, my lord.
No.
Not at all.
No such thing.
Lord,
They will agree with me and disagree with you.
Mr. Hari Vishnu Kamath agrees with
no,
Mr.
no,
Vikramnath.
my lord, he is a very respected person, my lord, but my lord, this is
In a lighter vein.
on the lighter vein, my lord, but this is like, my lord, a candidate celebrating based only on the Ruzan coming in the morning, my lord, and distributing sweets. That's what, my lord, the other candidate would hope, that these are only Ruzan and not the real picture. So, my lord, your lordships would, my lord, in that case, my lord, even if the governor sits on the bill, the solution does not lie here. The solution lies elsewhere.
Where?
Solution lies in
Where,
the
where?
political sphere. These are all political decisions. Such cases do happen, and such cases are, my lord, solved through that democratic process. Lord, it is wrong to believe that there can be circumstances where every other organ would fail, and therefore the only available organ would be this organ. Lord, this organ has protected fundamental rights, and your lordships are custodian of the constitution. No dispute on that. But there are certain problems which are, my lord, not solvable by the judiciary. They are to be solved, my lord, by political democratic process. When such a thing happens, my lord, we have to expect and accept that there are constitutional functionaries who are responsible and responsive, because they are answerable to the people every day and at least every 5 years. In a
The
situation
honorable
like
governor
this,
is not answerable to anyone.
pardon me?
The honorable governor is not answerable.
Governor, my lord, I'll answer that. I'll answer that immediately. The governor is the most vulnerable office. He can be removed without anything else. My lord, the moment the chief minister goes to the prime minister or the president and look at the facts of this case, this is what has happened, and such things do happen. That when governor sits over it, my lord, for good reasons, bad reasons, no reason, whatever, then political process takes over. And governor can be called back. Governor can be, some other person can go as a governor. Why not, my lord? And why can we not trust other constitutional functionaries? It's a matter of, my lord, the chief minister talking to the other constitutional functionaries that we are facing a constitutional problem. My lord, whenever something happens, my lord, in the judiciary, I'm not giving, my lord, a comparative example. My lord, the system takes care of it. There is an inbuilt system, my lord. Every problem does not come here on the judicial side. Your lordship takes a decision on the administrative side. So every problem is not solvable under Article 32 or 226 and thereafter 136. There are problems, my lord, under, I'm sorry.
Solicitor, the constitutional immunity to some extent is clearly worded in what advice given by the governor. Polycentricity, decisions involved in such a decision making. Why an assent is given, why a withhold has taken place, and why he refers it to the president for his opinion with a message. All these stand on one footing, and there is a constitutional immunity provided to all those. But we are actually today in this case referring to the procedure prescribed, which stands on a completely different footing. As regards the procedure, where is the constitutional immunity?
No, there is no immunity.
Number two,
I'm sorry.
it is exactly in this very context that the Kesare hymn, what you have read,
Yes.
they drew the distinction, saying that whether there is no question of deciding the validity of an assent there, but whether it was with respect to one part of it, another part of it, to examine it, they will look into it, is what they said.
That, my lord,
So therefore, an inquiry which is to be made whether the constitutional process, as Honorable Chief Justice has said, constitutional process of granting, not granting, or referring not being done, to what extent any kind of an immunity applies unendingly is the question.
Lord,
So we are not on the merits.
I bow down, Lord. I have understood the question. Lord, first of all, I am not basing my argument on any immunity. No, there is no immunity from judicial adjudication of any dispute except those issues which are not justiciable. I am not saying, my lord, immunity. For example, the governor takes the decision of 356. Your lordships have even hailed such decisions to be mala fide in Bihar case. In case of Bihar, your lordships were, my lord, Bhutta Singh. But court said that he was acting mala fide. He is not immune.
He didn't use that expression immune. We are substitute it with judicial review.
My lord, I am putting it slightly differently, my lord, not even judicial review, justiciability.
Okay, put it in, replace it with justiciability.
Yes.
Then answer it.
Yes, my lord, justiciability, my lord.
Not.
Well,
Can
justiciability,
there
my
be a
lord, flows.
constitutional logjam then? Can there be a logjam?
my lord,
You are saying that the only way to answer it is through political process.
my lord, every logjam may not have a problem, may not have a solution with the judiciary. My lord. I'm with profound respect, kindly don't take this as an arrogant way of, my lord, putting it. I'm saying constitutionally, every problem may not have solution before the court. There are several problems where the problems will have to be sorted out as per the constitutionally prescribed democratic political process. And the court would be, my lord, holding its hands, my lord, saying that it is non-justiciable. We do not have any standards by which.
Our powers under 356 are for a temporary period. The president rules cannot be,
It can't be.
then there are inbuilt safeguards.
Correct, my lord.
Within a limited period, it has to be placed before both the houses of the parliament.
Correct, my lord.
Then, if there is a dissolution, then, then
Election within a.
after 6 months, so in under 200, if we hold that the honorable governor has an unlimited power to withhold for time immemorial,
I'm just, my lord, just allow me to make the distinction. Article
then
3.
what is the safeguard for a duly elected legislature? Suppose a legislature which is elected by, say, 2/3 majority unanimously passes a bill. And we were giving example yesterday that if it is repugnant with the Central Act, then he may withhold it, or for some other reason, national security, so and so. If that be so, then if he doesn't exercise the proviso, it will be making the legislature totally defunct. The persons who are elected from that state, and if such a, it is not as if such a act is repugnant, then it is always subject to challenge. Or if it is contrary to.
Lord, may I answer? May I answer? Well, 356 is an executive power. It's not a legislative power, first of all. And therefore, my lord, there is.
To be ratified by the legislature, central legislature.
No, correct, my lord, but that's not the question here, my lord, is the decision taken in exercise of executive power under 356 is subject matter of judicial review. My lord, again, my lord, your lordship's concern is a concern that what happens, but the answer is this forum is not the solution. The solution is either amendment of the constitution, and till that happens, the political process, and such process does take place. Every state does not take a confrontation position. My lord, they do, my lord, exercise their my lord, diplomatic options, meeting, my lord, the constitutional functionaries. They persuade, my lord, discuss, debate. If there is some gap between one thinking and another, they try to bridge the gap, and ultimately the problems are solved. Your lordships are not flooded with state government saying that my bills are pending. So therefore, I am, my lord, repeatedly cautioning, my lord, not to examine the matter based upon some extraordinary or exceptional situations. Lord, now, my lord, I'll again come back to, my lord, page 259, my lord, State of Rajasthan versus Ramesh Chandra Mundra. Because here again, my lord, we would be creating a constitutional hierarchy that ultimately every problem will, the buck will stop here only, or for every problem in the country, which is not, my lord, in my respectful submission, my lord, the real heart and soul of the separation of powers. Some problems are problem of a nature where the solution cannot be here. My lord, please come to, my lord, page 260. My lord, Kalpana Mehta. My lord, it again, my lord, talks of the separation of power. My lord, I'll not repeat it, my lord. I may not repeat it. Please come to, my lord, 264. And I'll just read 2 paragraphs and, my lord, move on. My lord, I have already pointed out that there are certain core functions core functions. My lord, there are, for example, governor exercises several powers. But there are certain functions which are core constitutional functions in the nature of a legislative function. My lord, there, the doctrine of separation of powers, my lord. My lord, the problems, I kindly pardon me for giving this, my lord, example. It may not be a comparable example also. My lord, Supreme Court decides 100 cases, hypothetically, my lord, per month. There are several cases where they are changed in the curative jurisdiction. There is a possibility that even after curative decision, curative jurisdiction being exercised, some may feel that still we have not got justice. Somewhere, something will have to stop. The buck will have to stop somewhere. Look, the justiciability argument being met with that what happens if this situation arises is, my lord, in my respectful submission, my lord, ignores an argument that in every sphere of the constitutionally framed three organs, my lord, there are some issues where buck will have to stop somewhere. It need not be, my lord, it need not reach here, my lord. I'm sorry, my lord. I'm trying to phrase it the way it is possible. My lord, now kindly see, my lord. I'll skip, my lord, the rest of the things. And please come to, my lord, Aravalli Golf Club. My lord, I'm now on, my lord, other directions which are given 3 months period, give reasons. My lord, the Tamil Nadu judgment, the 3 months time fix, give reasons, and deemed assent. I'll come to, my lord, last point is deemed assent, whether there can be any conceptual concept of a deemed assent or not. And I have also enlisted the provisions where wherever the constitution stipulated that in absence of a particular act, something will be deemed, the constitution has provided. My lord, there is one beautiful passage, my lord, in Aravalli Golf Club versus Chendarhas. My lord, please see, my lord, the highlighted part only. Page 272.
270.
272.
For the deem, opposition on deem,
No, my lord. Justiciability.
that's true.
Lord, restraint, judicial restraint, that every problem need not be solution here. They, my lord, they have used, my lord, one very popular statement of Justice Cardozo. Judges must exercise judicial restraint. Your lordship, Simon. Judges must exercise judicial restraint and must not encroach into the executive or legislative domain. Vide so and so. Under our constitution, the legislature, the executive, and the judiciary all have their own broad spheres of operation. Ordinarily, it is not proper for any of these three organs of the state to encroach upon the domain of another. Otherwise, the delicate balance in the constitution will be upset and there will be a reaction. Judges must know their limits. I'm sorry, I'm reading the judgment.
Yes, yes, yes.
Must
You can read it loudly, no difficulty.
Why you feel sensitive? If you don't have,
Judges
we
must
don't have.
know their limits.
Yeah, we also say that whenever a petition comes before us,
Your lordships have always, my lord,
that it is
the
the-
separation of power is, my lord, kept in.
yeah, whenever we don't want to name the petitioners, issue such direction to the Union of India to frame this law. We always say that it is within the domain of the legislature, it is within the domain of the executive.
Serial litigators, my lord, where we, as I say.
Something is done and the first petitions are filed with 2 or 3 pages, and so therefore,
Yes, my lord, so that the reported judgment,
so therefore the then Chief Justice came with this policy in re so and so.
so and so.
Otherwise,
But that was suggested by me, that because there used to be a fight that mine is filed first, but his petition is registered first by the registry. So, so therefore I suggested that instead that it should be re so and so. The judges must know their limits and must not try to run the government. They have modesty. Don't kindly ignore it. 21. The
no,
theory
you can read that. No, don't.
The theory of separation of powers, first propounded by the French thinker Montesquieu in his book the spirit of laws broadly in India too. In chapter 11 of his book, The Spirit of Laws, my lord, I can skip Montesquieu. Kindly turn the page over, my lords. I'm sorry, my lords. My lord, page 274, para 30. Para 30, your lordships, my lords.
Yes.
The justification often given for judicial encroachment into the domain of the executive or legislature is that other two organs are not doing their jobs properly. Even assuming this so, the same allegation can then be made against the judiciary too, because there are cases pending in courts for half a century, as pointed out by this court in so and so. If the legislature or the executive are not functioning properly, it is for the people to correct the defects by exercising their franchise properly in the next election and voting for candidates who will fulfill their expectations, or by other lawful methods, that is, peaceful demonstrations. The remedy is not in the judiciary taking over the legislative or executive functions, because that will not only violate the delicate balance of power enshrined in the Constitution, but also the judiciary has neither the expertise nor the resources to perform such functions. Well, kindly turn the page, para 35. The constitutional trade-off for independence is that judges must restrain themselves from the areas reserved to other separate branches. Thus, judicial restraint complements the twin overarching values of the independence of judiciary and the separation of powers. In Lochner versus so-and-so, Mr. Justice Holmes, in dissenting judgment, criticized the majority of the court becoming a super legislature by inventing a liberty of contract theory, thereby enforcing in particular laissez-faire economic philosophy. My lord, kindly skip some my lord, part. In the nature of judicial process, Justice Cardozo remarked, and my lord, this, my lord, in my respectful submission, has withstood the test of time and is being quoted often. Justice Cardozo remarked, the judge is not a knight errant roaming at will in his pursuit of his own ideal of beauty and goodness. My lord, in Maratha reservation, my lord, also this is cited. My lord, knight errant, my lord, is kind of it's a fictional character which used to roam around at night, and whatever he thought is improper or illegal in the society,
Robin Hood.
he would correct it. So therefore, they say that this is something which should not be done. My lord, kindly skip the pages, my lord. Page 282. Lord, one organ of state cannot arrogate to itself the functions of another organ. My lord, this is, my lord, when we say if you don't do it within a particular period, there would be a deemed assent, or we would examine whether you had justification of not doing it in a particular way, not doing it on a particular time, etc., my lord, would be violative of, my lord, separation of
Then
power.
Para 38 also.
Para, my lord, 353.
38, page 275.
Oh, I'm sorry.
Moral of the story. Moral of the story.
Page 27. I'm sorry. Para 38. The moral of this story is that the judiciary does not exercise restraint and overstretch its limits. There is bound to be reaction from politicians and others. The politicians, I avoid it. The politicians will then.
Why avoid it? It's in a print. Yes. It's in a print.
Sometimes, my lord, politicians.
Clearly, because Mr. Sibal and Mr. Dr. Singh are here, it doesn't mean that we shouldn't read that.
No, they're respectable politicians.
So they are in the dual capacity.
No, even Mr. Wilson is here.
Yeah, Mr. Wilson is not to be seen. Mr. Reddy is also there.
Mr. Reddy is here, my lord. We have 3 MPs.
He was remarking, my lord, when he was mentioning about the parliamentarians, if Dr. Singhvi would be here when Wilson was there would have been 4 of us in a row.
And despite the parliament being in session, 4 of them are here.
That is how Parliament is adjourned now.
On the lighter side.
So the moral of the story is,
More, let it, your lordships have read it. But why? I'll read, but there is nothing. The moral of the story is that if the judiciary does not
May I
exercise.
just interrupt for 30 seconds?
Whereas there is this about this parliament and this. Whereas Mr. Jaitley and I were coming out of the house, and Mr. Chori was also coming out. He had just given a speech in parliament asking for a law to prohibit doctors, lawyers, chartered accountants, and anybody else to be MP. So when we came out, both of us spontaneously told him, we said, Sitaram, you want parliament to be a community of unemployed and unemployables. This actually happened with us, and all three of us are together.
Lord, I was on page 282, but please come to page 283. Lord, State of Rajasthan versus Union of India. Lord, this is a 7-judge bench judgment. Lord.
Mumbai total threat. Mumbai.
फरवरी के अभी हम आप
Precursor to Bhawan.
But this is precursor to Bomai. Bomai I will not read. I'll just paraphrase why your lordships would not rely upon Bomai, though Tamil Nadu relies upon Bomai. Just a bold part, but it cannot assume unto itself the powers of constitution lodges elsewhere or undertake tasks entrusted by the constitution to other departments of the state, which may be better equipped to perform them. The scrupulously discharged duties of all guardians of the Constitution include the duty not to transgress the limitations of their own constitutionally circumscribed powers by trespassing into what is properly the domain of other constitutional organs. Questions of political wisdom or executive policy only could not be subjected to judicial control. No doubt, executive policy must also be subordinated to constitutionally sanctioned purposes. It has its sphere and limitations, but so long as it operates within that sphere, its operations are immune from judicial interference. This is also a part of the doctrine of rough separation of powers under the supremacy of constitution repeatedly propounded by this court, and to which the court unswearingly adheres even when its views differ or change on the correct interpretation of a particular constitutional provision. Then bottom, a scrupulous adherence to this scheme is necessary for the smooth operation of our constitutional mechanism of checks and balances. It implies due respect for and confidence in each organ of our republic by the other two. My lord, particularly when, my lord, we are dealing with the highest constitutional functionaries of coordinate organs, my lord, in their constitutional capacity, my lord, not in their executive capacity, in their plenary power, which is legislative in nature, my lord. My lord, similar are other judgments, my lord. I am not troubling your lordships with, my lord, may be treated as read, my lord. My lord, thereafter, my lord, I have said,
Lord, even Bombay is not completely against you.
no, it's not.
Because
In fact,
even with this judgment in
it says there are manageable standards.
specifies what are outside the ken of.
Exactly, my lords. I'm grateful.
Some portion.
I'm immensely grateful, my lords. My lord, I have said restraint in exercise of judicial power in case of high constitutional functionary is a facet of separation of powers, which is a basic structure of the Constitution. And therefore, such restraint and non-justiciability should be read as a part of basic structure of the Constitution, to respect the separation of powers. My lord, then page 285, that even when there are undisputed judicial review positions, my lord, that legislature, executive policy, etc., there are inbuilt self-imposed restrictions. My lord, judicial restraint is always a self-imposed restriction. My lord, now page 287. My lord, your lordships must have these judgments. I am not reading them, but world over, these are judgments from other jurisdictions.
But you always say that we should.
I am not reading them.
should only follow our jurisdiction.
Yeah, absolutely. Well, therefore, I said that your lordships must have it, but without going into it, my lords. Lord, Thames cannot be more pious than Ganga, my lord. That is or Mississippi for that matter. Hmm? Petoma, my lord.
What is
Washington has Petoma. Anyway, my lord,
Krishna.
In the concurring opinion,
in some concurring opinion of Samsher Singh, my lords. Lord, now please come to 304. Oh my God, quote किया, which is- Lord, I'll not trouble your lordships because propositions are known. Lord, there are 3 judgments cited in Tamil Nadu case for the purpose of justiciability. First is Bomai case, as my Lord Justice Narasimha has said, my Lord, and I respectfully, my Lord, take that, my Lord, that there the Honorable Supreme Court came to a conclusion that there are judicially manageable standards. This was not a case of assent. Bomai was a case of 356. And therefore, it was an executive act and there were standards, whether you could have done it or you could not have done it. And therefore, the judicial review was exercised. My Lord, I have quoted the relevant paragraphs of Justice Ahmadi, Justice Verma, Justice Yogeshwar Dayal, my Lord, but I don't wish to read them. My Lord, second judgment which is cited is, my Lord, Manipur Tribunal. My Lord, that 10th schedule. Lord, that again, my Lord, Speaker is a tribunal and therefore there is no dispute that he is amenable to judicial review. He is not functioning inside the house or as a leader of the house while he discharging functions as a, my Lord, adjudicatory body under clause 6 of the 10th schedule. And another judgment, my Lord, which is cited, which is relied upon by Tamil Nadu judgment, is Maruram and Perarivellam. That if we can have judicial review over that function of the president, why not this? My Lord, Maruram and Perarivellam were cases where the Honorable President exercised purely executive act of pardon, which is subject matter of judicial review. And it was a case of Article 21 of a citizen. It was not, my Lord, a political question that way. Political, not in, my Lord, any derogatory sense. Political questions means questions arising out of functioning of a functional democracy in a quasi-federal constitution. My Lord, so these 3 judgments, my Lord, would not lead to any conclusion that it is justiciable. My Lord, Hoist and Kaiser, my Lord, in my respectful submission, holds the field. Then your lordships may, my Lord, kindly come to Lord, page 321. Lord, 321, my Lord, raises question number 9. My Lord, which the Honorable President has, my Lord, sought your lordship's advice, is this. Are the decisions, my Lord, page 328, 321, sorry. Are the decisions of the governor and the president under Article 200 and Article 201 of the Constitution of India, respectively, justiciable at a stage anterior into the law coming into force? Meaning thereby, my Lord, this is a subset that it is still at the stage of grant of assent, withholding of assent, returning the bill, etc., etc. Can someone come and say that this act under Article 200 and 201 is unconstitutional? My Lord, please have a look at, my Lord. Para 410, my Lord. Lord, I would only read.
Act under 20. Under 200, there is no act, still at the bill stage. So only when the assent goes,
It,
the act, and then, of course, act is.
then the bill can be challenged on all grounds possible. Pardon?
Exercise of 200.
Yes, yes, ma'am. Act capital A.
No, but-
Yes, yes, ma'am.
But if there is no decision, you have framed the question. Are the decisions of the governor and presiding president under Article 200 and Article 200 of the Constitution of India, respectively justiciable at the stage anterior into the law coming into force?
Yes, ma'am. My lord, but law comes into force when
Assent is granted.
is granted. But before that, it should have been granted, should not have been granted, should not have been referred to the president, should not have been returned to the house. Because here, my lord, we have faced a case where at that stage, my lord, the court has said that assent is deemed to have been granted. Then this is possibly, my lord, for the, not possibly, 100%, first time where the act came into force with the assent granted by the Supreme Court of India. My lord, your lordships on this side and on that side have seen acts which starts with this bill having been assented to by the President or Governor of India with a order dated so and so. My lord, these acts in Tamil Nadu mentions in the Gazette the bill having been assented by the Supreme Court of India with a judgment dated so and so. The court has exercised its jurisdiction at a stage anterior to the law coming into force. That is, my lord. And only see, my lord, one para, my lord, 414. My lord, your lordships would now again go back to Quixote. Quixote judicial review is available. Correct, my lord? No dispute on that because speaker is a tribunal. Still, 5-judge bench in Quixote says that no qui timate action is permissible. We can finally set it aside, but we can do nothing at an interim stage. My lord, please have a look at
That
this.
has been interpreted that any such order which prevents the speaker from exercising his powers would not be permissible, but any order by the court which enables the speaker to proceed further would be permissible.
Yes.
That Camat limit has been interpreted in so many judgments.
Yes, my lord. But my lord, point I am trying to make is that even where judicial review is undisputed, it is at a stage where the action is performed, the order is passed. Lord, please have a look for my satisfaction, page, my lord, 322, what my lord Quixote Holohan says, my lord, on this. Pella 110, only one para is, my lord, relevant.
Tamil Nadu was a reverse case, Mr. Solicitor. Here the complaint was that action is not being taken. That was completely reversal.
Correct, my lord, that is justiciability, whether court could have done something or not. Correct, my lord.
No, so therefore,
My lord,
we are not in an appeal of the judgment.
I am not.
Suppose what is our minds from day one? If for 4 years,
My lord, that your lordships will have to remove while answering this question. My lord, your lordship's interpretation cannot be based upon one particular instance.
Honorable CJ is asking on hypothetical case. Let's suppose there is a, it's not in one state.
and you are saying that it's, at least I think we are having petitions from 2-3 states now.
Yes.
Kerala, then
West Bengal.
West Bengal, then Punjab.
Yeah, I was missing you.
Yes.
I was.
How can he be missed?
You here? No, there are fixed seats.
No, you objected to his petition on Monday itself. So
Yes. And your lordship now knows why they were opposing reference to a 5-judge bench.
but then we said that whatever we decide here,
Certainly.
will
I am
affect
on
all
that.
these
That
matters.
was on the lighter side. Nothing to turn on the merits.
The fallacy of this.
No, we quite appreciate whether a time bond program could be issued such a 3 months, 1 month, and then deemed and all that. But consider a situation where the governor is bound to either way grant asset, but if for 4 years just sits for, then what happens to the democratic setup of the government? What happens to the will of two-thirds of the majority of the legislature of that state?
I would not, my lord, like to answer, my lord, answer the way I'm going to answer. But suppose, my lord, the president, my lord, as I'm at the cost of repetition, is
We're not talking about president, honorable president, we're talking about the governor.
the governor. I'm giving an example of a president of India where a citizen approaches him that my trial is pending since 10 years and the sessions judge is not taking up the matter, and my offense is punishable with only 7 years of imprisonment, and my husband is in jail. Can inaction on part of the judiciary empower the president to declare him as having only undergone the sentence? It may not be a comparable example,
We don't
but
think
this is
there
how separation of power.
That exactly.
This
We
is
feel-
how separation of power. This presupposes that every problem will have a solution only ultimately, Lord, at the doors of this court. And political solutions or democratic solutions are no solutions. Lord, there are solutions, Lord, problems in functioning of the constitution where, Lord, there may not be a solution necessarily by judicial adjudication. It's not necessary, my lord, to hypothetically believe that every solution.
No, we are not hypothetically believing it. We are having petitions at least from the fourth
No,
state.
no, I am saying something else, my lord, that necessarily presuppose a belief that ultimately we will have to solve every problem. My lord. And my respectful submission is there are problems where this may not be the only solution, or this may not be the solution. That's my respectful submission. I'll proceed further.
Like, for example, how political executive came up with 10 schedule. It's not a court's invocation. That's what you said.
Yes,
10 schedule.
Parliament did it because there was a problem of ayaram, gayaram, as we say. Defection was rampant.
The preamble itself, preamble of the constitutional amendment itself begins with that problem.
Correct. So, my lord, some problems, the solution can come only from within the system. That is, my lord, the doctrine of separation of power. There are certain core legislative functions, there are certain core executive functions, there are certain core judicial functions. But at the moment executive tries to step in, the judicial domain, your lordships have restricted. And rightly so, on the ground of separation of powers. Well, that is how NJSC went. NJSC was, my lord, declared illegal. The entire political spectrum of the country was on one page. Unanimous. It was passed unanimously, ratified by the two-thirds of the state, but your lordships protected the separation of powers. That no, one person also from the executive would not be a part of the collegium. My lord, respectful submission is, my lord, the separation of power is a balancing act which balances the constitution. And it will have to be a two-way street. Some issues are non-justiciable, but that's the respectful submission. My lord, kindly come to 324. Is it permissible for the court, my lord, please 324, and I'll just, my lord, orally argue, but I'm not reading it. Is it permissible for the courts, and this is a very, very important, my lord, question which the Honorable President wants your lordships as, my lord, guidance on. Is it permissible for the courts to undertake judicial adjudication over contents of a bill in any manner before it becomes law? My lord, why this question?
I think
It is that question, it doesn't.
I'll
arise
tell your
at all.
lordships why it has arisen. What is, my lord, the scheme of the constitution? The governor assents the bill, withholds the bill, or refers it to the president. Forget two options. Forget fourth option. He refers it to the president. The question has arisen where there is a two-judge bench judgment which says that it is prudent for the president, before granting assent, to make a reference under Article 143 of the Constitution to this court because the question of repugnancy is a legal question, meaning thereby the president will come before your lordships by way of a reference that I have received this many bills from the state. Kindly take that direction. And it is otherwise imprudent for me, as the High Court, Supreme Court has said, to take decision on my own, and therefore I am now requesting you to tell me whether it is repugnant or not. It proceeds on two fundamentally flawed assumptions. A, the Honorable President, or in this case, Honorable President, is unable to decide for herself whether there is repugnancy or not. And number two, your lordships will examine the bill at a stage anterior to it being an act and decide whether there is any repugnancy or not. And if your lordship says no, you grant assent, then the president will grant an assent. My lord, do we have a dual structure where before granting assent to a bill, unless the president is herself or himself, my lord, is of the opinion that we need opinion. My lord, there are 2 or 3 references made on the bill that I would like the Honorable Supreme Court to examine and guide me. But otherwise, do we presume that president will not be able to on her own take a call, and therefore it is prudent that president in every case comes before the court under a reference with 143, my lord. I'll just read it, my lord. Your lordships need not open. Whenever in exercise of powers under Article 200 of the Constitution, a bill is reserved for consideration of the president on grounds of patent unconstitutionality, they are of such a nature so as to cause peril to the principles of representative democracy, the president must be guided by the fact that it is the constitutional courts which have been entrusted with the responsibility of adjudicating upon the questions of constitutionality and legality of an executive or legislative action. Therefore, as a measure of prudence, the president ought to make a reference to this court in exercise of his powers under Article 143 of the Constitution. So before the bill becomes an act,
This is, that's question number 12. We will examine that 12 in that context. But this issue relating to examining the bill at a bill stage is consequence of that question. This question doesn't
12.
stand on its own. This 12 doesn't stand on its own for the reason that nobody
Because
is asking
He
the
has
bill to
framed
be
that
examined.
question, he has framed that question because of those observations.
This is it's coming before.
So before the president decides whether to grant assent or not,
Lord, kindly,
he
kind,
should give our.
Lord, kindly see,
Consequence of.
Lord, kindly see the, my lord, hazard of this. Now, kindly see the hazard.
I would readily agree with you that what should be the answer to that question.
Kindly see the hazard. My lord, kindly see the hazard. I'll give a simple example, my lord, and there is no answer to that example.
I don't think that they would be opposing.
They would be, my lord. Let me place it. Let me place it. Lord, suppose
Civil as
they should,
this was fine.
no, they should not, because it's not a government or B government.
No, rewriting the constitution.
Yes, Lord, the difficulty would be this. Lord, if in every case the president as
Then we'll have to leave all other work and only devote ourselves to giving advice to the Honorable President under 143.5,
Lord, the
145.3.
Lord, the difficulty would be, it would be a matter between your lordships and the president. There would not be anyone else. Your lordship says that no, there is no repugnancy.
No, but then under 145.3, we have to sit in a bench of 5 for giving that opinion.
Minimum 5. Minimum.
Minimum 5 years.
But minimum 5 is when the constitution was framed, where the total strength was 7 judges. It is that, my lord,
Now, you want to make it 21
At least.
difficulty is, my lord.
out of 34.
My lord, difficulty is, my lord, suppose the president comes before the honorable president, requests your lordship's opinion. Your Lordship says either way that it is not repugnant. Well, I am a citizen of India. I am affected by that act. How do I challenge that act before the High Court? Because it is already got an approval from your Lordships at a pre-act stage. Therefore, my lord, this question, I will not labor it, my lord, beyond the point. Then, my lord, may kindly see, and another point, my lord, which just for the purpose of stating, my lord, Article 143 is an enabling or empowering provision. It's not
It's a discretion of
it's
the
a
president.
discretion. It's not a
Whether
mandate.
the president wants to seek
Justice.
advice or not, it is for her or him to decide.
Advice is always a discretion, whether to take advice.
Less the president making a power, more a justice doing power.
Yes,
That's what actually he.
it's an
invoked.
enabling provision, my lord.
Invoke that for the when he invoked that for
Okay.
doing justice.
My lord, that is what, my lord, I have page 327 is this question. I will not labor much on this. In page 327. In light of the constitutional scheme governing the powers of the president, my your lordship gets. And my lord, I am not arguing as an appeal.
These are all connected, all these three are
I am
connected.
not arguing an appeal because this question is likely to arise now. Therefore, I am my lord, before your lordships under 143. It's not an intra-court appeal. The argument from the other side would be that you will be sitting in appeal.
No,
I am
that
not.
preliminary objection has already
yes.
been heard.
Yes. So then, my lord, your lordships have seen, my lord, the question. My lord Justice Narasimha has seen. Please come to page 370 directly.
370.
370. So this is deemed assent. Whether there can be a deemed assent, this is a facet of Article 142.
Three 70
370.
370 of the submissions.
370.
Of the submission.
Lord, this is a limb of Article 142. Your Lordships are aware of Article 142. Lord, I am not citing any judgments, my Lord. I have quoted, my Lord, for your Lordship's ready reference, but deemed assent is granted, my Lord, under Article 142. The question is, my Lord, can this honorable court substitute itself in place of another constitutional functionary and do what the Constitution requires that another functionary to do? Deemed assent would mean your Lordships substituted your Lordships as the governor, and your Lordships declared that the assent is deemed to have been granted. Lord, on this, my Lord, please come to page 375. Lord, 142 cannot be used to amend the Constitution. My Lord, forget deemed assent for reading time limits, for directing time limits, for directing a manner of exercise of power, etc., is not part of Article 142. That is my respectful submission. That your Lordships have used, my Lord, to do complete justice when there is a cause, when there are two parties, where there is no other constitutional or legal solution, but it can never be used to amend the Constitution. And so far as deeming is concerned, please come to page 375. We have collated the provisions of the Constitution wherever
Provision is provided for.
wherever deeming is provided, contemplated, the Constitution provides that if this doesn't happen within this time, it is deemed to have happened. That only the Constitution can do, and not, my Lord, under 142. My Lord, the one question, my Lord Justice Narasimha initially said, my Lord, that Article 32 and 131, that your Lordships may perhaps not like to answer that question.
I sure that's all.
No, but that can be kept open. I have no difficulty. Otherwise, we can assist your Lordship.
Issues can't go under 226, it must go under.
Whether a state can file a petition under when there is a
The last issue,
yes,
last question that are posed to us.
397, my Lord.
Read that.
Because this is a federal dispute between state and the center. Of course, through president and through governor, but ultimately dispute between two federating units. Question 14, does the Constitution bar any other jurisdiction of the Supreme Court to resolve dispute between the union government and the state government except by way of a suit under Article 131 of the Constitution of India? All federal questions, my Lord, are amenable under 131. My Lord, tomorrow, your Lordships may have a writ petition by one state against another state regarding, my Lord, some other dispute. For that 131 is the provision, constitutional provision, that all federal issues amongst federating units, state center, state, two states, etc., will be adjudicated upon only and only by this court only, but under 130. Whether a 32 petition would lie, because 32 petition lies only for violation of fundamental
rights. But you know the nature of 32 petitions that we are faced with every day in our now.
My Lord, this is the time, my Lord, now to, my Lord, say that 32 is my Lord, something.
I think that you need not.
Lord, it's a very sacrosanct
Such a
remedy.
question need not be answered in this fashion. Well, that's my respectful submission. Well,
My Lord,
this
let
really
me
does
also
not directly-
consider,
It
Lord,
does
these are-
not directly arise.
Keep it for
Yeah.
some other time.
Yes.
My Lord, I'll make a request. No, this is a presidential reference, not a petition or SLP. Therefore, instead of my taking a decision,
No, we will say that in the fight.
my Lord, can I come back, my Lord? If necessary, I'll take 20 minutes.
No, there's ample time. We can come back by Tuesday.
Therefore I'm saying, but I'll have to take instructions, my lord. This is a
Sir.
presidential reference has its own sanctity, my lord. It cannot be.
If it comes from the Honorable President, that the Honorable President doesn't insist on these questions.
Therefore, my lord, let me have that, my lord.
Otherwise, it doesn't arise also.
It's the direction on the Tamil Nadu case.
We know what happens to 131 suits.
Yes, yes.
Yes.
But, my lord, again, my lord,
Now, I couldn't even frame the issues between you and Mr.
Yes, yes.
Kapil Sibal.
my lord, my lord, I am posing a question to myself on a lighter side. Can, my lord, on that ground, the president frame it? That is separation of powers, my lord. There are always problems, my lord. There are always issues which are genuine issues. Your lordships are flooded with litigation.
Let us not touch those issues.
Well, I'll, my lord, take instruction because I can't withdraw.
No, it's better you
Take instruction.
Thanks, sir.
So my lords were asking something. My lord, just I'm extremely
I
sorry.
wanted to see where the direction of Tamil Nadu case, about directing it.
The Honorable President to seek opinion of this court. Where is the direction of the judgment?
Yes, I'll just. On prudence, my lord.
No. That direction.
Tamil Nadu judgment.
When there is a repugnancy, the president must seek the opinion of.
Lord,
How is it couched?
Lord, page 12575,
1 minute.
direction number Roman 20.
20.
Your lordship gets, my lord?
Where it
May I
is
read,
found
my
the
lord?
There you go, Tamil Nadu judgment. It is in which volume?
power for the president.
Lord, it is volume 531.
31.
531, page 12575.
The president must be guided.
Page number?
Page 12575.
12,000.
There are other places also, but this is in the direction portion.
Roman 20, Roman 19.
Hmm?
Roman
20.
20.
The responsibility.
Your lordship gets, my lord?
Yes.
Whenever in exercise of the powers under Article 200 of the Constitution, a bill is reserved for consideration of the President on grounds of patent unconstitutionality that are of such a nature so as to cause peril to the principles of representative democracy, the President must be guided by the fact that it is the constitutional courts which have been entrusted with the responsibility of adjudicating upon questions of constitutionality and legality of an executive or legislative action. Therefore, as a measure of prudence, the President ought to make a reference
Right.
to this court in exercise of his powers. Otherwise, President would be in contempt.
Not paying. It is, if it was-
Even repugnancy is ultimately to be decided by a lordship. No?
Obligation of-
Repugnancy at the stage prior to consideration by the Honorable President.
Therefore, the question that can it be examined at a stage anterior to it becoming an act?
At least Mr. Sibal has considered that he will not argue.
Well, there are better things.
Tacitly, yeah. Dr. Singh may.
I'm reserving my Bhawan till next week.
Lord, these are my respectful submissions. But if there is anything to be in the rejoinder, we'll submit.
Who else are going to argue? Mr. Maninder Singh, Mr. Srivastava?
Mr. Salve would be assisting your lordships. Mr. Kaul, Mr. Maninder Singh, perhaps Mr. Jethmalani, but we'll, my lord.
Mr. Guru is also there.
Yeah, Guru is here, but I'm sorry. Yes. And Mr. Navare is also there.
But you divide the timings among yourself for Tuesday.
We shall.
My lord, we'll do that. We'll finish on Tuesday, my lord.
Yes.
We'll do that. That you know.
And by 4 o'clock.
Absolutely. Not the other matter.
And it is before 4 o'clock.
So,
We
Kaul,
kept
you
us
have-
busy till 5:30.
Yes, my lords. I plead guilty to it, my lords.
So We wanted to finish it before we start this.
Yes, ma'am. Yes. May I, ma'am, with your lordship's permission? Because some of the issues will be overlapping because we have to present our.
Your arguments always begin that I will never repeat what has been already
My
happened.
lords, some-
That is only to be followed in
Yes,
speech.
but my lords, the nature is such that I have to repeat some of
The
this.
ordinary matter that is followed in speech, so in such a matter it is bound to happen.
Yes. My lords, firstly,
Do you have submissions?
please, my-
Are your submissions? here?
no, my lords, I'll formulate with the next
You just ask.
1 hour, I'll formulate in my own words some of the issues.
Yes.
Important issues. My lords, as far as construction of Article 200 is concerned,
You are for which state?
for the state of Madhya Pradesh. As
far
far
as-
as the construction of Article 200 is concerned, my lords, the issue of governor sitting on a bill, not acting, what are the options available to the court, I'll deal with later. That has issues of justiciability, judicial review in it, I'll deal with it later. On the pure construction of the article itself. Our respectful submission for your lordship's kind consideration
Can
is
you formulate your proposition as far as construction of Article 200 is concerned?
there are 3 options in the main body of the article.
In the main provision.
Yes, each have a finality and a consequence attached to them. And each have to be preceded by an affirmative act of a declaration. The
And
each is followed by, each is preceded by
Declaration.
a affirmative act of a declaration. The words used are shall declare. And then the words used are either that he assents to the bill,
each is preceded by an act of declaration.
declaration, which says that either that he assents to the bill or that he,
Therefore, since you begin, now it has to be preceded by a declaration.
yes,
So if the honorable governor, for time immemorial, doesn't even declare that he is withholding the sanction, and even in such a case, this court would be powerless.
Maharaj, that is why I respectfully submitted when I opened that the issue of justiciability and the supposed inaction of some governor, I'll deal with later. Let me first deal with the construction of Article 200 and then what would be the options available to your lordships in exercise of your lordship's jurisdiction if a situation does emerge where there is a governor who's been sitting on a bill for years, not acting on it. We've had the benefit of your lordship's views and I'll attempt to address that question later. But for the moment, my lords, let me first address 200 as it stands, the reading of 200. Now, my lords, each of these actions, as I said, declarations has a consequential effect. In the case of an assent, it becomes an act, the bill. In the case of withholding assent, constitution benches have said that the bill falls.
False.
And in the case,
Unless.
I'll come to that. I'll come to that. And the third part is it goes to the president. It is reserved and goes for the opinion of the president. True. The fourth option, my lords, is actually in the nature of what fell from my lords, more in the nature of a preliminary option. That is, as part of the consultative process, because as your lordships will recollect, Article 396, where the subchapter begins, the heading is legislative procedure. And your lordships have said that even the governor's decision in this is part of the legislative process.
It is a part of the legislature.
Legislature and legislative process. The heading is legislative procedure. 196 is preceded by saying legislative procedure, and I'll show the judgment, my lords. I'll show the judgment on the point. The purpose of that is, my lords, under the proviso is that there is a consultative process also envisaged, where the governor may send recommendations, may want the House to reconsider, could be a case where he's willing to assent but feels certain things require a bit of tweaking, may think that there are constitutional concerns or issues of repugnancy or many other issues, and I need to send it to the president. But before sending it to the president, let me at least first send it to the House, expressing what my views are, and after that it comes, I can always send it back. What he can't do after returning it is that he cannot thereafter himself withhold assent. Only word used there is shall not withhold assent. Shall assent or reserve for the president are not mentioned there. That's the only thing, the only option which goes away after you return the bill. But this returning the bill, my lords, A is presentation to him of the bill for assent. The words used in the proviso are not on withholding of assent, he must return it. The words used are presentation to him of the bill for assent. Now, if return of a bill was to be treated as an adjunct, as has been sought, to withholding of assent, it could have easily said in the main body, withhold assent and return. The words used in the proviso are as soon as possible after presentation to him of the bill for assent. And I'll tell you, Lordships, why the words used as soon as possible here are. The reason as soon as possible here are that the framers of the Constitution imbibed an expediency to it, given that this is really the preliminary option, where first the consultative process takes place before he could exercise any of the three other options. It's not that he needs to do it, but if he chooses to do this, then let it come back after that so that either of the three options which are there in the main part could be exercised. The reason, my lords, the Constitution may in judgment, after saying he has three options, referring to the main part, adds the word unless to the second option and does not add it to any other option is this, my lords, that if the Honorable Governor gives his assent, naturally the bill becomes the act, it doesn't fall through. If he reserves it and sends it to the president, it still is a bill which goes to the president for his consideration. It is only in the case of where the withholding of the bill takes place by a declaration that it falls through. So the words used are in the judgment are that this bill will fall through, unless of course it is sent to the, that is the purpose of the bill. That unless in a constitution when judgment can't be picked up to mean that the proviso to Article 200 says that the return of the bill is an adjunct to withholding of assent. That's why, my lords, I respectfully started by saying that the first words in Article 200 are a positive affirmative act of shall declare. And shall declare with those three options. Shall declare withholding assent, it falls. Shall declare giving his assent, it becomes an act. Shall declare it is reserved for the president, it goes to the president. But there is a preliminary option given there, which of course the rider, that if you exercise that option, then one of those three options are taken away from you, which is the second option of withholding assent. That goes, there's no doubt about it, no quibbling with that.
That goes, so either he has an option, either to give assent or to send it to the president. That would be a summary.
Grateful, my lords, because I'm very grateful to Honorable the Chief Justice that the words used then in the proviso are the governor shall not withhold assent therefrom. It could have said shall assent. Didn't say so. Shall not withhold is the option.
The option of withholding goes.
Yes.
But still, according to two options remain.
Yes.
Either to give assent or send it to the president.
That's right. Because, my lords, as I respectfully submitted, the philosophy behind it is that as being part of the legislative procedure or process, there is also an inbuilt consultative mechanism. And I'll come to some of these memorandums, my lords, when I come to the issue of timeline, and I'll show to your lordships that even Dr. Ambedkar, while dealing with the duties of the governor, said he must advise. It is his duty to advise. It is his duty to interact. with the ministries concerned on proposed legislations. I'll come to that article.
Friend, philosopher and guide.
Philosopher. Very grateful. So under Article 167 of the Constitution, my lords, a chief minister is duty bound to ensure that all ministries send the requisite information and material to the governor on any proposed legislation. And I'll build that argument as I go along. The purpose being that he is not sitting there as a rubber stamp. That is why judgments of this court have held that there is explicit discretion vested and there is implicit discretion vested in the governor. Word discretion may not have been mentioned in Article 200, but your lordships in your lordships various constitution benches have said he's not bound by the aid and advise, irrespective of the aid and advise. The discretion is there to act on his own. It is part of that consultative process that he in his wisdom, maybe with recommendations, maybe without recommendations, maybe with suggestions, maybe without suggestions, sends a bill back as a fourth option to the legislature, to the assembly to debate on it. He no doubt in the process then gives up his second option of withholding. That's the framers thought is the best option. That's in their wisdom, they've decided. We are bound by it. But to say that the proviso means that the moment you withhold assent, you are duty bound to send it to the Legislative Assembly is wrong. Because, my lords, neither does the Constitution provide for it, nor does the textual context provide for it, and there is no basis for it to come to this conclusion at all. And that is why I started by saying, my lords, that the word shall declare, and all constitution benches, even for the main part, have said three options. And the words used are either. Either are all three options mentioned there. There is no basis to say that because it uses the word as soon as possible, this is an adjunct to withholding and thus should be sent back. There is no constitutional basis for this at all. My lords, my next argument for your lordship's kind consideration under the same head is that if your lordships were to also see the historical significance and evolution of Article 200, your lordships would see that under the Government of India Act 1919, under Section 12, return of the bill for reconsideration to the council was an option. Withholding of assent was also an option. It wasn't that it was an adjunct. It was an option. And the words, my lords, used in the article were, instead of declaring that he assents to or withholds his assent from the bill, return the bill to the council for consideration, for reconsideration.
So I think we need not go to the pre-independence statutes because 200 has been now enacted after due deliberations in the Constituent Assembly, and therefore we could be guided by the deliberations in the Constituent Assembly rather than going to the.
I'm
70 years have passed.
Absolutely. No, my lords, I'm very grateful. The only reason I said was
we'll follow the learned solicitor in that rather than following the British laws. Now we'll follow the.
Yes, my lords, except for saying that this proviso always existed as an option. That's the only limited point I'm making. I'm not saying that your lordship needs to go to the Government of India Acts for interpretation, but to have it as an option is not an unknown thing. It is historically as an independent option always existed. And in fact, my lords, only to this limited extent, the government, it's really a discretion argument. The Government of India Act 1935 had the word discretion in it. Article 200 did not have the word discretion in it. And despite that, constitution benches of this court said that irrespective of the aid and advice of the Council of Ministers, independent discretion is vested in the governor while exercising power under Article 200. The purpose I'm saying so, my lord, when I marry it into the time argument, the timeline argument is the Constitution envisages a back and forth between the state and the center between the ministry and the governor, information being given, deliberation, application of mind, formation of opinion, sending back to the assembly for reconsideration. It's a whole process which is provided for. It's not as if a bill comes, immediately declare one way or the other, and that's the end of it. That's not what it envisages. Manoj, my second argument, my lords.
So the word is not, discretion is not mentioned,
Yes.
but still options are given. So when more than one options are given, it is presumed that there is a discretion.
Yes. Yes.
And Article 163 discussions would also show
Absolutely.
that they said that Dr. Ambedkar as well as T.T. Krishnamachari, they said that as and when we progress towards the other articles, the provision in 163 is to safeguard that wherever discretion is provided in the foregoing articles, same would be preserved. It can't be a generalistic.
I can't put it better, my lords, than 163(1) and 163(2). Both, and then the discussion, it says that there is explicit discretion, there is implicit discretion. And clearly this is a case which is now interpreted no longer res integra, that discretion does exist, and for good reason it exists. My lords, one more question, my lords, and Justice Surikant in particular put to me when I briefly intervened on the last date, was that if one option is exercised, would it mean, when we are answering a constitutional reference, would it render the other options ocious? My lords, that's a question. Please correct me if I'm wrong, my lords. That's a question which fell from my lords. My lords, the answer to that would be, my respectful submission would be, the very fact that the article gives 3 or 4 options obviously gives you a choice to choose one. Merely because you choose one does not make the others ocious. It's a matter of choice. So if, for instance, an assent is given, naturally then assent can't be withheld. Then it naturally can't be sent to the president. If it is sent to the president, naturally it can't be withheld or assent be given. So the natural consequence of opting for one of the 4 options is that the others have not been opted for. But this is not an ocious situation where an interpretation to a clause or a part of the constitution renders another article or a clause, as would happen, say, any other case, ocious. It's not an ocious situation. That's all that I'm saying, my lords. It's an exercise of discretion by the governor on one of the options provided to him.
The other facet of this very argument was that whether the power of the governor to withhold also include the power to withhold temporarily.
My lords, yes.
The question is not of taking away the power, question of reading the power of the governor. Whether the power to withhold also include the power to withhold temporarily.
My lords, to answer that and taking cue from what fell from Justice Narasimha yesterday, that is why I started by saying that also the proviso in a way becomes out of the 4, a kind of the first preliminary option of before taking a all 3 others have a categorical finality to it. Assent, act, withhold, false, false, reserved for president goes to the president. So before that, as part of the legislative process, as part of the consultative process, send it. So to that extent, my lords, that's what my answer is.
According to it, it's possible for the governor, for the honorable governor, to first exercise the option under proviso. And then after the bill comes, then exercise either of those 3 options.
Either of the 2.
Either of the 2, because withholding goes.
That he knows. The moment he sends it back, he is giving, because the constitution mandates that. Even if he wanted, he can't do that. So that goes. But the other 2 options remain. But he thinks in his wisdom. And I said, my lord, there may be cases, leave aside withholding. There may be cases where the governor actually feels this is a bill which is fit for an assent. But I feel something needs to be tweaked or changed. Let me send it back once. Or he may think, yes, there are serious constitutional concerns of repugnancy or otherwise. I need it to be sent to the president. But before it is sent to the president, let me first suggest to the House.
Let them have an opportunity to.
Yes, let them give it. So that is why I respectfully submitted this whole argument that a proviso is a necessary adjunct to option 2 is wrong. It is contrary to the bare reading of the provision itself. And there is a reason why it's been put the way it's been put. An option as a fourth option is nothing new which has been done. It's not an argument being made by us for the first time. It has a historical basis. That's the only limited point I said this one.
One of you will also enlighten us that what is the meaning of shall declare?
What, my lords?
What is the import and meaning of the expression shall declare?
Shall declare. Yes, ma'am.
Is it a kind of formal declaration, informal declaration, implied declaration, express declaration?
Yes, my lords. Yes, my lords. Implied or expressed, my lords. I'll have a look at it. Very grateful, my lord.
So Shankaran, you are on which side?
He's always here.
No.
This-
Whether you are on a fence or
Genuinely, personal opinion, one shouldn't take extreme position.
Who are you appearing?
Where the
Intervenable.
interventions have been allowed on the first place.
Okay.
We are giving advice to the President of India. I think we
No,
should-
not we. The court is giving. Yes, sir. No, the 143 empowers only the court to give advice
Then,
to the president.
Then, without your assistance, we cannot give our advice.
Assisting the court, my lord. We are not advising the governor. Yes.
Well, may I just put this down because we can't see your lordship, my lords. We'll put it back, my lords, at the end of it.
Even
Look.
the learned, the solicitor.
Yes.
We will
And-
not put it back as long as the CV goes on.
Your lordship, because here there is no petitioner and respondent. And genuinely, I am saying this, my lord, without any other meaning. Mr. Sibbal, my lord, I am looking forward to his arguments because he has been a parliamentarian. He has been an elected person answerable to the people. And my lord, we know
So he has been a person answerable to the parliament also.
Parliament, that's why I was coming to that he was also in the governance and how it affects the governance when I come to, my lord, the question of judicial review or, my lord, justiciability. Because people, your lordships are aware of late, my lord, since last 20-25 years, my lord, you cannot take a voter on a ride. They catch the elected people.
You cannot.
Take voters on a ride, which earlier used to happen. They catch you that I have this problem, you are not solving me. And that is why, my lord, I always say that irrespective of the color of the political party, an elected person cannot be denounced that he is just an elected person. And
But who says that?
I will show. I'll show who said that, my lord.